perhaps all three of those cases. Whichever way we go, we're going to let the listeners decide which way we're going to go and how we're going to go and how long we're going to go. The first case is, and before I get ahead of myself, we possibly could have a guest tonight. Guest said that they would come through. We shall see. Surprise guest at this particular juncture. But anyway, the cases that we're going to dive into, one is the case of the 3 corrupt police officers who were on trial, and 2 were convicted, and 1 was found not guilty. He wasn't acquitted, because those of us who was there seen what happened. The second case is dealing with the theft of black home ownership, black property, black real estate. And the third case is regarding the filing of a PFA, a protective order of protection from abuse. And we say that many people, men and women, but the reality is it's mostly applicable to women, though men have to file them at times because they get entwined, but majority of the people who have to find them are women, or file them, are women. So those are the 3 cases that we're going to deal with, and so we can go ahead and dive into that. The first case is the case of the 3 police officers who was on trial for perjury in the Anthony Wright case. Marty Devlin, Emmanuel Santiago, and Frank Juszczymski. He has a jawbreaker name. I think it's like Polish, but it's spelled real difficult. But those were the 3 officers that were on trial for committing perjury and other acts in the Anthony Wright trial. And those of us who were there, we saw what happened. We saw the defense attorney for Marty Devlin, the one who was found not guilty. We saw him literally bully the jury. We seen him respond to and drudge up some of the most vicious white supremacist tropes that one could imagine. We listened and watched him as he invoked the OJ trial. Yes, that's right. He invoked the OJ trial, even though the trial was about the 3 defendants on trial for committing perjury. Somehow he interjected the OJ Simpson trial. Also, too, this particular attorney, I can't remember this clown's name off the top of my head. It'll come to me. But what he did was he retried the Anthony Wright case, even though 2 juries, one in a criminal case, acquitted him of all charges, and the other in a civil case, which said that he was actually innocent and that the city of Philadelphia has to pay him X amount of dollars. And so they lost twice. Nevertheless, the attorney, one of the attorneys, particularly Marty Devlin's attorney, he proceeded to retry Anthony Wright, and he attempted to excoriate him, and he viciously assaulted him with lies upon lies upon lies upon lies. Even though the jury in the criminal trial acquitted Anthony Wright of all charges, which included murder, this particular attorney kept referring to Anthony Wright as a murderer over and over again. Now, where the prosecution did an excellent job in trying the case overall, but there were times that they should have objected, and that was one of the times that they didn't object, and they should have. Each time that he referred to Anthony Wright as a murderer, they should have objected. And of course, when they mentioned the O.J. Simpson trial, they definitely should have objected. But by and large, it was a team. Only one prosecutor was really on the team. The other prosecutor was acting like he was a hostage. He wanted to be on the defense team so bad it was just pathetic. But one prosecutor held it down and did a great job. He could have did a better job. Probably you can always do a better job, particularly when you didn't get 3 guilty verdicts. But he did a good job. And so this particular lawyer, whose name, for the life of me, I can't recall his name. Brian McGonigal. That's his name. Brian McGonigal. And rumor says that he actually came out of retirement just to try this case. I don't know how accurate that is, but that's what the rumor said. And if you was there to see it, it was just absolutely disgraceful, the manner in which he stooped to white supremacist trope after white supremacist trope, simply to badger the jury, intimidate the jury, and excoriate Anthony Wright, the man who had been exonerated as actually innocent, not from one jury, but 2, one in the criminal and the other in the civil. But nevertheless, he was allowed to get away with that. And the judge didn't do anything to stop it either. In my opinion, the judge she was frightened. She was very timid. She kept laughing. And many times she laughed, it was inappropriate. Now, I do understand on a human level, sometimes if, the situation is a little intense, that you have nervous laughter. I get that. But far too many times she laughed and it was inappropriate. And people in the courtroom was kind of unsettled by her laughter. And I could see the laughter was an effort to try to make light of the matter, not disrespect the matter, but just to be lighthearted. But it was inappropriate. It was inappropriate almost every single time. And one time, when it was appropriate, the jury had came out deliberations, and it was a real intense moment. And the judge, I can't think of this judge's name, but it'll come to me. She told a joke, and the joke fell flat. And she said, well, I just did that to, I'm paraphrasing, of course. I just did that to bring a little levity to the situation because it's a very intense situation, which it was. And in my opinion, she just started with that and that alone, and that would have been suffice. But the joke was, it just didn't fit, and it was inappropriate. I get what she was trying to do, but you could see that she was intimidated by the circumstances of the trial. Having these 3 white police officers on trial for lying in the murder trial of a black man, and knowing full well that this one particular attorney kept trying to retry the case. And kudos to the general media, because they did a good job in pointing out and seeing. This is probably the only thing they really did a good job in, because the rest of it, they was just asking softball questions. But they did a good job in identifying the fact that all this lawyer did was just retry Anthony Wright. And Anthony Wright wasn't even on trial. But that lawyer, Brian McGonigal, he made sure that he was. So that's the first case, and we can get into the particulars, because quite a few things happened in that case that nobody knows about, that we were Johnny on the spot, and we peeped it, and we know that the community needs to know about what happened in the case, particularly some of the things that happened behind the scenes that were just vicious in terms of the guilt of the individual police officers involved. And so we won't be able to get into that. The second case that we could delve into is a case in which, now what we did, the latter 2 cases that we brought up, they're going to be a composite sketch of multiple cases so as to not divulge what cases we talking about and individuals involved because of the dependency of the cases. So we don't want to blow it for the litigants in those cases, we want them to have their rights vindicated. So we use a composite sketch of multiple cases so we can talk about the issues in a general sense, but not get into too many specifics so that we won't know. But however, these cases are indicative of systemic white supremacy practiced not only in the Philadelphia court system, but in Philadelphia County court system and the Pennsylvania court system, and yes, the American court system. So we can get into that case as well, where the theft of black-owned home properties are being stolen, where black land is being stolen, and where black real estate is being stolen under various ruse to do so, to separate African people from their property. The latest iteration of that theft comes from Act 135. And we can get into all of what Act 135 entails and what it does for our folks. This is WBN Communications, the Beverly Nation Host Intern Show, on air now from Nigeria. Dial in at area code 605-562-0444 or area code 717-734-6904. Press show identification number 5461150 #, then 1 and #. Also press *2 to talk to us live on air. Brought to you by Ngozi Time Multimedia LLC. Yeah. So we took care of first thing first again. So we good to go. So where were we? We were talking about the second case. And in the second case, we can get into that and the details of how this wholesale theft of black home ownership, mostly of which are elderly African people, and most of those elderly African people are African females, who've owned their homes for 40 years, 50 years, 60 years, 70 years, and they want to leave it to their children so that the children can pass that wealth on generationally. To generate generational wealth, anybody knows anything about home ownership, they know that it is the number one engine to generational wealth. And so these white boys in the city of Philadelphia who are running down on these black families and stealing their property, their homes, their land, and their real estate, do so because they do not want African people to have generational wealth. Part of the overarching scheme for these Europeans in the city of Philadelphia is gentrification. And it's genocide through gentrification, displacement, disenfranchisement, etc., etc., etc. And then the last case is about a woman filing PFA, a protection from abuse order, and all of what that entails and how the city of Philadelphia is operating as it relates to women and men who seek to file PFAs to get their former spouses or their former significant others to just chill to the next episode because they, in some instances, they just be off the chain. At best and at worst, they just be outright violent or murderous. And what PFAs do, at least legally, it puts a separation between the filer and the individual who is the violator. So that's the third case, and we can go into all of the particulars about what it entails to file a PFA and what the procedure is like for the individual filing the PFA and what protections it provides and what position it puts them in terms of vindicating their rights. So we can get into one of those cases, two of those cases, or all three of those cases, if the callers so desire. We're going to let the callers decide where they want to go and how they want to go. So where are we? Okay, we're just going to talk about the first case. Now, the first case, which is perhaps the most engaging or it's the rawest because it just happened. I happen to be there in court every day. The very first day I got there late, extremely, so much so that I didn't get a chance to hear the introductory testimony of the witness, who was Anthony Wright, exoneree Anthony Wright, and that was a disadvantage, of course, because I wanted to hear everything, but I was juggling cases in other courtrooms. So as a court watcher, we have to be there for the client first and foremost. And also too, it's kind of odd as a setback, sort of, that nobody actually talked about the case. I got comrades, or a few, who were in the courtroom, and they never called me. They never called me and told me that they were going to be attending this corrupt police officer trial. I had to find it sort of serendipitously because one of my comrades had mentioned that one of the police officers, Marty Devlin, the most corrupt out of the three, the one who was actually found not guilty, that he was going to be testifying, but because they didn't give me any details on the case, the assumption was that that he was testifying in someone else's case, not his own. The thought never hit me that it was actually his own trial. And so I asked an attorney comrade, and he gave me all the documentation, the judge, courtroom that he would be in, the court number, and so forth. And then I popped up and I seen, oh snap, this wasn't him testifying at someone else's trial. This was in fact him being tried along with his two criminal conspirators, Manuel Santiago and Frank Juszczymski. So I got there and I was like, whoa, bam. I said, I was a little pissed because nobody had called me and told me that this was actually, in fact, their trial. It should have been the biggest in terms of, in the legal community, it should have been the biggest case talked about. And it's deep because the undercurrent, the implications and ramifications of this trial should have been, well, legally speaking, was gargantuan. But in terms of politically and culturally, it should have, the turnout should have been much more robust, in my opinion. At times, I was the only black man in the courtroom, which was crazy. You can wrap your mind around that. And then other times, you know, different people would come through. This one brother, I never got his name, but he's definitely in the trenches. He came a couple days, and he was well informed as to what was going on in terms of the testimony. Any of the things that I had missed, he briefed me on those things. So he was there. Sister April, she came through. She was there for, I think, 2 days. That was a beautiful thing. We bonded based on what we witnessed going on, the injustice going on in that courtroom. Also, Dr. Chinchilla was in there, which sort of pissed me off because she didn't call me and tell me that she was going to be at the trial and that the trial was, in fact, starting. Nobody called me and told me that that trial was starting. And we should have been spreading information, you know, hither and thither. Social media, flyers, handbills. We should have been talking about it in church. We should have been talking about it in the mosque. We should have been talking about it in the synagogues. We should have been talking about it in the temples. We should have been talking about it in the barbershops. We should have been talking about it in the supermarkets, etc., etc., etc. And we weren't. And to our detriment, because there were many things that transpired in that case that have implications and ramifications, far-reaching implications and ramifications for our community and for us moving forward. The first thing I can say, oh, one second, let me back up. I have to say this. I am not a lawyer. I am not a lawyer. Thank God I'm not a lawyer. But I'm not a lawyer. And we share this legal dissertation for educational purposes and informational purposes. And that's important. And so any questions that we raise, any law that we articulate or assess, if you want to know its accuracy, look it up yourself. Research it yourself. And if something is said that touches you in your personal legal circumstances, we recommend that you go consult with your lawyer or your attorney. For me, that's a difference. It's a difference between an attorney and a lawyer. Most people would tell you there is no difference, but there is a difference. Well, when we say counsel, we incorporate both of them. Consult your counsel if there's something you hear that you think that would be beneficial to you in your legal pursuits or the legal pursuits of your loved ones or anyone that you may be supporting in terms of their legal battles in a Philadelphia courtroom, in a Philadelphia County courtroom, in a Pennsylvania courtroom, and in an American courtroom, or for that matter, any courtroom that you find yourself in. So yeah, I had to get that out the way. I'm not a lawyer. So now, where were we? I think I lost my place. It'll come back to me. So the things that transpired in that courtroom were things that our community need to know. And the way things unfurled told us that those things, we have a caller on deck, so we can go ahead and put the caller through and see what vibrations the caller has and where the caller would like to go, whether it's case number 1, whether it's case number 2, whether it's case number 3, or whether it's all of the above. So go ahead, let our caller do their thing. Caller, are you on with us yet?
I am. How are you tonight?
I'm absolutely magnificent. And what's your name, caller?
How do you... This is Ava Holly. I'm the host on the network also, and I really just wanted to call and support your show and tell you that I find your approach very cool. I find your voice very interesting. So I wish you much success on the WBNN network. You're going to be great.
Well, when's your show? When's your next show? When's your next show?
My next show is on the 7th. And we have a returning guest coming on, so I'm really excited about that. It'll be 9:30 Eastern Time, and I'm right outside of Atlantic City, so I'm not too far from you. And, yeah. So,
what's the guest's name? What's your guest's name?
My guest's name is Michelle Robinson, and it's going to be a fun show. So I hope you guys will tune in, and I just want to wish you the best on your internship, and then, your best on being a regular host on the network.
We shall see. And I thank you. I thank you greatly as well. Oh, one last question. One last question. Do you know the name of your show?
Oh, of course. It's the Casual Chat.
Casual Chat. I like that. That's sort of calm and cool. I like that.
Well, I'm enjoying listening to you. I don't have any comments on the cases yet. I like your approach to what you're doing, and I'm going to listen in a little bit longer.
Okay. Thank you very much. Appreciate you. Okay, now where were we? We were talking about the corrupt cop case. The three monkeys. see no evil, hear no evil, speak no evil. But they do it all the time. The things that transpired in that courtroom were something else. One of the things that we saw that was just utterly shocking is that when before I get there, let me back up. Most people didn't know that while one of the police officers that was on trial, his name was Marty Devlin, that was the one who was actually acquitted or found not guilty of the case. Folks didn't know that somewhere else in the building, a brother had filed a petition for what is called the Brady violation. And Brady is just the name of the case, Brady versus Maryland. And the case is about when the prosecution withholds exculpatory evidence that says you're innocent, or inculpatory evidence that says you're guilty. They have to give either forms of evidence. The prosecution has to give it up in the process, which is called discovery. And that's before trial even starts. And the reason being is that the accused can prepare a defense based on the evidence. If the evidence suggests that you are guilty, then you want to build a defense. You may build a defense to mitigate that guilt or to disprove the guilt outright. And if it's exculpatory evidence that says you're innocent, obviously you want to highlight it and show that the prosecution has no ground to stand on. So now that was what we moved forward with, the discovery. And what folks didn't understand is that while this dude, Marty Devlin, was on trial, someone else, another litigant in a separate case somewhere else in the courthouse, filed a petition, a post-conviction, which is an appeal. And in his appeal, he asked the trial court to grant him a new trial based on newly discovered evidence and the prosecution's violation of Brady, which is they withheld this evidence, and this evidence should have been divulged at trial because he could have used it to do a series of things, like discredit the witness, to devastate the prosecution's case in chief, and moreover prove his actual innocence. So the judge in that case granted him the new trial, threw out the conviction, gave him a new trial. And so they had made arrangements with the prosecution and the defense. They got together and said, listen, we tired of this. The man had been in prison for, I think nearly 30 years. He had anywhere from 27 to 30 years in prison already, and he just wanted to get out. And so he knew that the system was corrupt, so he wasn't trying to fight no more. So he made the arrangements to take a plea bargain. Once he got the new trial, his conviction was vacated and thrown out. The judge took his plea right then and there, and he resentenced him. And the brother was eligible to go home within like 2 weeks after that. But the interesting thing was that the issue he raised was that a homicide detective had used what is called a photo array. A photo array is a series of 6 to 8 pictures of suspects. And the photo array, oftentimes, whoever the suspect is, they'll have the suspect's picture in that array of pictures, the 6 to 8 pictures. And the pictures are not supposed to be not supposed to be obvious. It's supposed to be a mixture, so that when a person looks at it, they can't tell. Like if this, let's say the witness says the person was light skinned, they're not supposed to have a photo array of 8 pictures where the only light-skinned person in the photo array is the person that the police want to find guilty or accuse it. Then they go out and get 7 dark-skinned people and put the suspect in there with the 7 dark-skinned people. And so when if the person says that they light-skinned and they show them the photo array, the only light-skinned person in the photo array is the person that the police want the person to pick. So that's a tainted identification. So it's supposed to be a mixture so that when a person look at it, they're not swayed in any way. So this one homicide detective had used showed the witness a photo array, and the person who the homicide detective thought did it was in this photo array, and the witness didn't pick anybody. He said, I don't see the person that committed this crime. And so the homicide detective went and said, oh yeah, he picked such and such. He picked the accused. And yeah, and he logged it and wrote it down. And so when they get to trial or evidentiary hearing before trial, or was it during? It was during trial. And the witness took the stand, and they was asking the witness, yeah, didn't you identify the dude in a photo? He said no. They showed me a photo array, and then he said the detective's name. They showed me a photo array, and in that photo array, I didn't see the person who was guilty of the shooting. And the homicide detective said, I picked somebody. And that was a lie. I didn't pick anybody. And he said it right in court. And what's so devastating about this, the homicide detective who did that was Marty Devlin. While this dude was in the courthouse, in this particular courtroom, going over these set of facts and circumstances, Marty Devlin was on trial for committing perjury and doing the same fucking thing in another trial. And the jury never got a chance to hear that. Now, what you think the jury would have said if they knew that in another case on the same day that they trying this boy, another case is involved where he did the same thing in the other case? Do you think he would have got away with that in a separate case? I think not. And the community don't even know that that happened. And that is just absolutely devastating. Another thing that happened in that case that was crazy is the O.J. Simpson referral. One of the things that they did, you've seen with your own eyes, which was illegal, and retrying the case. Their case was so poorly prepared, and by they I mean the defense. The other defense lawyer was Fortunato Perry, and then the third one, I forget this guy's name. He got a plain Jane name, and he's not that good either. His name will come to me, or maybe it won't. But anyway, they were so poorly prepared that they relied on white supremacist tropes to carry their case. And one of the things that the lead defense attorney kept saying over and over again, that Anthony Wright was a murderer. And one of the things I did at the end, after everything was all over and they was doing a press conference, and the so-called local media or the white media, they were asking the lawyer all these softball questions. And so I just jumped right in. I said, excuse me, Attorney McGonigal. I said, during the trial, the regular media says that you retried the case. Clearly that's what happened. How is it that the first trial and the retrial, they acquitted him of all charges which incorporate murder, and you kept referring to him as a murderer? So isn't that you retried him in spite of what the evidence said? And he just ignored me. He just went, he says, Anybody else got any questions? And none of them picked up on it. None of them said, well, like, yo, ain't you going to answer the dude's question that just asked you? Like, he was stumped. But he was like, well, I ain't got to answer to you, nigga. You know what I'm saying? We're going to move along. And it was deep, and it was telling to me, because the rest of the media, they wasn't even prepared themselves. They didn't even know that. They didn't even know by sitting in the courtroom. And some of them was in the courtroom. Not every day, but they was in there. They seen and heard enough that they weren't even prepared enough to ask real questions about what transpired in this case and how his client was found not guilty and the other two clients were convicted for the same thing. And he had did the most damage. He had did the most crime. He had did the most hiding, the most withholding, the most perjury, the most lies, and it was and the receipts for it were overwhelming. And his lawyer, he just simply just sat and bullied the jury, so much so that when they read the verdict, and I never seen anything like this before, that when they read the verdict, the judge told them to stand and face the jury. The defense lawyer, McGonigal, he actually went and stand in front of his client as if he was a shield in front of his client, putting his body between the jury and Marty Devlin. And Devlin was hiding behind him too, like the coward he is. You know what I'm saying? And I'd never seen anything like that before in my life. And then McGonigal like balled his fists up and like poked his chest out. Like I dare you to find him guilty. I'm like, yo, he shouldn't even be allowed to do, like, yo, it was on some real just straight up and down bully shit. And excuse my European. It was just straight up and down bully, just bully-ish. But it was to just see it is to really know the length to which they are willing to go in order to usurp the law, to usurp the Constitution, to usurp the Pennsylvania Constitution, the United States Constitution, and any so-called rights that black and brown, and to a lesser degree poor white people, have under those rights. And these lawyers do it ad nauseum on a regular basis, day in and day out. And a lot of times too, folks, and this is another thing as well that was really telling after all this. I was watching these Negroes after all this was over. They came up and they were shaking this boy's hand. The lawyer boy, I can't think of his name again. His name comes and goes. They was shaking his hands. They was like they was proud, like, yeah, this my man. No, he ain't your man. He despised you and everything that looked like you. One of them false relationships. Anyway, another one of the things that happened at the trial, which was crazy, is that Jack McMahon was there. And Jack McMahon, if anybody knows who Jack McMahon was, Jack McMahon used to be a district attorney. And back in the mid-'80s, I think 1986, 1987, when he was an ADA in the Philadelphia District Attorney's Office under the leadership of then District Attorney Ron Castile. Ron Castile later on went to become the Chief Judge of Pennsylvania Supreme Court. But anyway, Jack McMahon made a prosecutorial instructional tape. That is a tape in which he was teaching novice prosecutors how to strike from the jury pool black people illegally. And if you've never seen the tape, Google it. It is the Rodney King, is the prosecutor's version of the Rodney King tape. And it's teaching novice prosecutors how to beat down the rights of black and brown people, specifically black people. Just beat them down. Like, so what? The Constitution of Pennsylvania says you can't do thus and so. Beat them down. Beat their rights down. Don't matter. They don't count. So what? United States Supreme Court says that you can't do this. Beat them down. And in the tape, he was telling them how to beat what is called Batson, Kentucky versus Batson, which is the United States Supreme Court dealing with the preemptory challenges of jurors, of potential jurors. And Batson said that you can't strike jurors from a jury pool based on race. You have to have neutral answers. Excuse me. You have to have neutral answers for do so, but he made it clear that he was striking them and teaching these novice prosecutors to strike black people off simply because they was black, particularly when the defendant was black. And so that's a double whammy. It's denying the rights of the accused sitting in the chair waiting to be tried before the bar of justice or so-called justice, and it also denies the individual black and African soul wanting to do their civic duty by sitting on the jury. So that's a double whammy. And so that's who Jack McMahon was. He made that tape. And for those who don't know, the reason how we found that tape is because once he left the district attorney's office, he became a defense attorney, and he mostly defended corrupt cops. He challenged Lynn Abraham, who was the prosecutor after the tape was made. The tape was made during the Ron Castile administration, but then Lynn Abraham replaced Ron Castile when he was appointed to the Pennsylvania Supreme Court. And she wound up being district attorney for like 18 years. But anyway, Jack McMahon challenged her to be the district attorney, and at the time he was fighting in a case. And the case was the Wise and Hack case. If anybody remembers that case, it was basically like the Center City case where they said that these two individuals raped this stockbroker. She was out in the morning jogging, and these two boys jumped on her and raped her, beat her, and I can't recall whether they actually murdered her or they just raped her. Either way, it was one or the other. But they had accused these two dudes, Wise and Hack, of doing this. Now, DNA came up, and the DNA said that they was innocent. And Lynn Abraham made all this fanfare about how guilty they was, but the DNA says that they were innocent. And so Jack McMahon used that opportunity to take a pop shot at Lynn Abraham and said, yeah, I'm running for DA. Lynn Abraham, she's protecting these racist cops. And in this case, everybody was white. The victim was white. The accused were white. The prosecutors was white. The defendant, the defense lawyers was white. Everybody in the trial was white, but he's talking about she's protecting racist cops. And so, as good fortune would have it, she was so irate that he said she was a racist. Really, she's a white supremacist, just like Jack McMahon is a white supremacist. They're both white supremacists. Good white supremacists, bad white supremacists. If you can wrap your head around that. But when Jack McMahon said that, she got so irate, she magically went and found the tape. And it was the tape that Jack McMahon had made like 4 or 5 years earlier. Now, mind you, Lynn Abraham had that tape that entire time. For that whole time she was in office, for those 5 or 6 years, she never divulged it. She never showed it to anybody. And then once he made that comment, and her comment, her clapback was, oh, if he's calling me racist, then he has to explain why he made this tape. And I sent copies of that tape to all the attorneys and the people that blah, 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 blah. And the tape blew up. It was a national debate on prosecutorial misconduct. It was more compelling than the actual case in the United States Supreme Court case dealing with the Kentucky thing. In Texas. The tape was more compelling than even that, the precedent, which means that they really have to usurp the precedent. Yeah. Those we're gonna press pause right now because we got another caller in the K. Come on, caller number 2 on deck. Let me hear you speak. Where you at, caller number 2?
Oh, hey, this is Des calling from Little Rock, Arkansas. I have a show on here called U-Turn.
Okay.
And I'm enjoying the conversation. So I got a couple of questions for you because I'm curious about you. This is your first intern show?
Yes, absolutely.
Well, you're doing great and very interesting. So you said you're not an attorney. Are you a paralegal?
No, I always call myself a lawyer who hasn't been authorized by white people.
Oh, understood. Okay. And you had also said something about a good white supremacist and a bad white supremacist, so that would you give some clarity on that?
Well, the term good white supremacist was tongue-in-cheek. And it's those who pretend to really like African people, who pretend to like brown people, First Nation people, Asian people, but in fact despise them. Of the two, of the good white supremacists and the bad white supremacists, of the two, the good white supremacist is the worst one. Sort of like euphemisms for good cop, bad cop. In that dichotomy, the good cop is the worst one, because that is the one that can win your trust, get you to let your guard down, and then punch you in the face. And so that's the same thing with the good white supremacist, bad white supremacist. The good white supremacist is the one that would lie to you and smile and act like they not really against you, but they in fact for you. They have they have other titles. Most people refer to the so-called good white supremacists as liberals, and the bad white supremacists as conservatives. But neither one of those titles really are descriptive or exclusive as to the thinking of a white supremacist. It's really more so about the behavior. So, I mean, if that answers your question in terms of the good and the bad, the good is not really good, but as it relates to the bad one, the one that spews white supremacist epithets and doesn't use any sophistication, and you know exactly where that person, he or she, stands. Whereas the good white supremacists will smile and pat you on the back and tell you how nice you are and tell you how intelligent you are and tell you how different you are from other African people, and things of that nature. But of the two, they're the most dangerous. And then you even have those who are conscious and others who are unconscious. White supremacists who are conscious white supremacists, and then those who are unconscious. They are dangerous as well, because they do things and they think that they're doing good, but they don't know it's because they was raised in a society that basically seduced them and groomed them to be the white supremacists that they are.
Understood. Thank you so much for the clarification on that.
Not a problem.
Recently, I was mentoring a group of white women.
Okay.
That are at a domestic violence shelter.
Okay.
And we were discussing their hiring process. So I was talking with the staff. And I was letting them know, hey, y'all don't have people on staff that are representing everybody. And we got into a little bit of a heated argument. And I told there, and then they started with, oh, well, did you see we hired 2 women of color? I said, yeah, I saw that. And they're like, well, see, there's something to get excited about. I said, I'm not excited about that. And they're like, what do you mean? I said, you know when I'll get excited? I'll get excited when the entire staff is Black women. That's when I will get excited. Now I'm not excited. And they're like, well, it is a first step. I said, I'm not saying it's not a good first step to make, but this was a step that needed to be taken a long time ago. I said, but, y'all are just trying to toot your horn here, or have me toot your horn and pat you on the back and tell you what a good job you did, when this is something that you needed to be thinking about, not but now, but right now. Like, not yesterday, but last month. And I was talking about comparing a couple different people, some problematic behavior, more or less consulting them. And I was like, this person here is much more dangerous than the other one. They're like, what do you mean? I said, all right, well, let's do a pop quiz. I said, y'all tell me who is more dangerous. I said, the red hat wearing bigot that openly talks about how she wants the wall and all this nonsense, okay? Or the blue dot, the one with the rainbow flag, and, maybe they go and put some pictures on social media how they've been out at a protest, a Black Lives Matter protest. Which one is more dangerous? And they all got it wrong. I said, oh, well, the red hat. I said, no, wrong. That's not it. They're like, well, what do you mean? Are you saying that you're not dangerous? I said, no, I know I'm dangerous. I said, but the difference is I'm going over here to the next town over to make sure sidewalks get put in. So I know exactly what to do with how much danger I hold.
Interesting. Basically, you just gave another example of what I was talking about.
Yes. Mm-hmm.
Very good.
Thank you.
Thank you for your call.
I followed you there.
Thank you for your call. I appreciate you too, as well. We got caller 3 in the queue. Caller 3, what's popping?
Hello, it's not the ordinary, it's unique. I'm calling to support your show, and you have hit a lot of amazing views, because everything that you are saying, we have dealt with that in Louisiana and Mississippi, also here in Texas. And I just wish that I know it's with the change of time. It might come, a change might come, it might not never come. But I just wish the world would just turn colorblind and treat each individual, each client the same, instead of, giving a white person lesser time than they do the Black person, or they're trying to make it seem like that the Black person is more dangerous than the white person. It's average, because sometimes each individual creates their destiny and their fate is not in the hands of us, it's in the hands of our higher power. But when you see in society where Blacks do the same crime as a white person, and the white person gets a slap on the wrist, and they try to put the Black person under the jail. Racism is still tough, even in the new millennium. So I appreciate everything that you're bringing out and everything you're saying. And my show will be aired on May 8th on WBNN Communication. It's not the ordinary, it's unique. And then you can tune in to www.podbean.com, The Groove with me and Dr. O Ngozi. And then you can also hear me live every other Saturday with the Unique Parker Experience. And, you know, I just appreciate everything that you're saying, and you're saying a lot of great things that you need the public to know. And peace and blessings.
Don't forget to give us don't forget to give us the topic of your show.
The topic of my show will be flatline.
Oh, I like that.
Flatline runs very tough.
I like.
You know, everybody's talking about flatline. Well, you know what the flatline is if you tune into the show.
I like that. I like that. Yeah, I like that. Flatline. Okay. Suck it now. Go on with your bad self. Anyway, are you finished? Are you finished with your comment? Oh, all right, the caller, she stepped, which is cool. The caller before her, she touched on the issue of the abuse of women. That's our third case dealing with how to file a PFA. The caller left so quickly. We could have engaged that particular case. But anyway, when she talked about one of the caller that just spoke, one of the things you left so quick, sister, I wanted to have a few words with you. One of the things in dealing with some of the challenges that we face, they're the same challenges, but they're different challenges in all 50 states. I'm working on a book now called 50 Shades of White Supremacy, and showing how in each state in the Union, how they practice their brand of white supremacy, their shade of white supremacy. Because a lot of times when we talk as if our brand of white supremacy is worse than, everywhere else, when really it's just a different shade. Same white rabbit dog bit you, bit me. But one of the things that we have to do, in my opinion, is we have to watch language. And you were talking about the racism, what you referred to as racism, in Mississippi and Louisiana and et cetera, et cetera. Let me try to give you some clarification on just that word and language and how important it is. In the American lexicon, they have multiple words, and those words are used to keep us as far away from reality as we possibly can get. Words like race and all of its derivatives, that is racial, racism, and racist, are all euphemisms for white supremacy. So as long as you're talking about race and racism or racial or racist, then you're not talking about white supremacy. You see, the word race, if it's spoken, it confuses the listener. If it's written, it confuses the reader. Why? Because it doesn't say who is doing what to whom. But when you say white supremacist or white supremacy, you identify the culprit and the crime right from the rip. And then there's no confusion as to who and what you're talking about. And so, and part of what they do in American language is they get us to be emotionally tied to words. And so much so that we use these words in an emotional manner and articulate them as if we're saying something deep or profound, when really actually what we're doing is that we're strengthening the chokehold, the psychological chokehold that this word or words have on us, simply because we don't know what the word actually means. And I say that to say, because There are times when you tell someone that the language, word, or phrases that they're using are detrimental to them, and because they're so emotionally attached to those phrases or word or series of words, they continue to use them sort of almost like in defiance. And it's like an emotional attachment to the word, because all this time our oppressors have told us that the words that represent strength in reality, they redefine. The meanings of words are always the same. The only thing changed is the definitions. And the definitions are changed predicated on what the social engineers or the controllers of the society would like you to have you think or do, simply because you would be able to be easily controlled. And so the definitions that they give words of strength, they redefine those words to be weak words, words that make us stay away from those words. And words that are actually weak, they redefine them as words of strength, so we gravitate towards those words. So in essence, we're gravitating towards words that are weak, but they've been redefined as being strong. And then words that are actually strong, in fact, they redefine them as weak, so we run from those words. The words that we run from are actually the words that will liberate us, and the words we run to and embrace are the words that enslave us. Those are the words that we become emotionally attached to. Tripwires. They use tripwires so that when we begin to understand this process and start reading and studying linguistics and etymology and words, we begin to get towards words of power, and those tripwires go off, and emotionally we shut down. And now we want to stay on or articulate or emotionally blurt out words that are weak, but we've been told that these words are strong. And we get into these arguments with one another, so much so that we actually want to, at times, commit physical harm against one another, simply because someone is trying to point out that the words you're using are harmful to you, are harmful to your family, are harmful to our people. You actually want to go to blows with them. You'll get to the point where you actually hate them, and want to, see them in a certain way that allows you to take up arms sometimes against them. If you can imagine that, if you can wrap your head around that. But words are the key to everything that we do. And if we're not cognizant of the words that we use, what they actually mean, the meaning is always different from the definition. And if we're not cognizant of those things, we wind up embracing and holding on to words that enslave us, and we reject words that actually liberate us. Malcolm said that in a war of national liberation, we can't aim for at the puppet. We have to aim at the puppet master. And that's about words. And words will deceive you and make you think that the puppet master is really the puppet, and you chasing the puppet and not the puppet master. And a lot of times that's how we wind up going at one another. Okay. The nightly promotion is the WBN Communications, and this is a Beverly Nation host intern show, and we're on air now from Nigeria. Dial in at 605-526 at Ngozi time. Multimedia LLC.
Yes, indeed. And of course, we are proud tonight for our brother Muti, Ajamu-Osagboro, and his first intern show here at WBN. And to proudly announce for the 11th time.